This meeting is now being recorded.
Hi, Mary.
Hi. Thanks for joining. I just waited a couple minutes to make sure that some more people got on, but I'm going to go ahead and start. So if you guys don't mind putting your phone on mute just in case you're doing something in the background so that everybody can hear. And then I'm certainly happy. There is, I believe, on your web page a Q&A box. Also, though, what may make more sense is that my contact information is at the end of the slides, and I'm happy to talk to anyone individually or answer questions. So my email and phone number is there. So that may be better than trying to ask questions through the PowerPoint or through the web. But certainly if you do have questions that you think that would be important for other people to know as well, you can either ask me towards the end or you can go ahead and just type a question in that box. Okay, so the topic tonight is really to give everyone an overview of estate planning for families of children with special needs, and also to touch on guardianship as well. And I want to start with a question that gets asked a lot, which gets asked by people that have children with special needs and people that don't have children with special needs, and that's really, why do I need a will? What's so important about having a will? And there's a number of reasons why having a will is important. There's certainly tax reasons, which really depends on whether you are in a situation where you may have to pay estate taxes, either New Jersey or New York and federal. There's different exemptions against the estate taxes, and certainly having a properly well-drafted will make sure to take advantage of those exemptions and make sure that as much as possible can pass tax-free to your kids as possible. But of course, for everyone, there are many non-tax reasons why setting up a will is important. We want to make sure that assets pass appropriately to your kids, for example, to beneficiaries, that we have the right trust set up for the kids so that the kids aren't receiving assets at a young age, to make sure that the assets are more protected from a child's creditors, particularly in a marriage or divorce situation. And we want to make sure that we're naming the people that we want to name to be in charge of the trust and also to be in charge of our estate. And then, of course, the will is also where you name the guardians for your kids. If you have children who are under the age of 18, in your will, you would specify if something happened to the parents of your child, who would be the guardians. If you have a child over the age of 18, but who you believe needs a guardian, or, maybe at some point the parents, you are appointed guardian of your child, but you want to make sure that a judge knows that you have a backup plan, that there are certain people that you would want to be the guardian to serve in your place if you were to pass away. You could name those under the will as well. When you have a child over the age of 18, a court always has to approve of the guardians, but certainly having your wishes spelled out in your will is a very good indication for the judge of what your wishes are when it comes to who you're choosing as guardians. I'm going to skip through some of these just so I can get towards so I can get into more detail with regards to the special needs trusts. But when you die without a will, assets pass pursuant to whatever state laws that you live in when you die. I'll tell you that there's a theme that runs through these laws. They're all a little bit different. But in most circumstances, if you guys could just put it on mute, just so we're not hearing what's going on in the background, that would be great. When you don't have a will, the assets typically go under most states' laws to a child when they're 18. And regardless of, what challenges your kids may or may not have, most people don't want any children to get assets at age 18. So obviously the fact that, if you don't have a will, all of these things, all of these trusts aren't laid out and all of your wishes aren't laid out, is certainly less than ideal. So the use of trusts, again, I touched on this a few minutes ago. The use of trust is really wide-ranging, and most of our clients, again, regardless of what challenges their children may or may not have, regardless really of how much wealth they have or don't have, are very interested in leaving assets in trust for their children after death. These trusts can deal with issues such as, certainly special needs issues, which we'll touch on. They can also deal with issues such as drug or alcohol abuse, which unfortunately some families certainly struggle with. And they also can provide, even if none of those issues are relevant to a child, having a trust set up for a child can certainly help, again, if you have a child that becomes a doctor or a lawyer or is in some profession where liability is an issue or lawsuits are a potential concern, and also in divorce contexts. If you leave assets outright to a child and they get married and that money gets commingled with other marital assets, if they get divorced down the road, it's possible that what you left your child could be essentially split up in a divorce and half goes to their spouse. So having trust set up within your wills, within your documents, will help with all of those issues and help ensure that the money stays in trust for your children and ultimately passes to grandchildren instead of to a child's spouse or some other family member. Choice of fiduciaries is important, so the executor administers your estate, figures out what you own, files any tax returns that need to be filed, and then ultimately distributes out the assets according to the terms of your will. At that point, if there are trusts that are set up under the will, the trustee takes over. And the trustee is the person who invests the assets and ultimately makes decisions about whether or not to make distributions to a child or to pay for certain expenses. And the choice of trustee is especially important with a special needs child for a couple of reasons. One, it's very likely that this trust may last for your child's lifetime. And obviously the people that you know now that may be appropriate to appoint as trustee, your child may outlive them. So it's important to try to name as many trustees as you can in order to at least have some length of time where you know that the people that you appoint will still be around to help administer the trust for your children. Also, another challenge with special needs trusts for some people is that there are some children that obviously have more needs and have more specialized care than others. And so you want a trustee that is not only, trustworthy and good with money and able to invest the assets, but you want to make sure that you have a trustee who's sensitive to the fact that that there may be certain caregivers that need to be hired. There may be programs that your child should be in or that could be available to them, and the trustee really needs to be the one to, if not themselves, at least be involved and know enough to know, the right organizations that can help, the right social workers, the right people relevant to your children's lives that can guide them and give them really the best sense of what's appropriate for your child as your child progresses through life. Of course, at some point, the people that you know may run out. And so in the documents we draft, at least, we always have a number of ways to deal with that. One is we say that the last surviving trustee can appoint a successor. And then some clients say if everybody I know runs out, then I want to put either a nonprofit. There are a handful of nonprofit organizations that will act as trustees of special needs trusts. That's one option. And the other option is there are some banks and trust companies that will also act as trustee. There are some banks and trust companies that will not act as trustee of special needs trust because it is considerably more work and personal effort that is involved than what I would call, a trust for someone else where there are no special needs involved. So some banks will do it, some will not. The ones that will do it, there is generally a minimum amount. Usually it's around $1 million before, it makes sense financially for them to do it. But it's something to think about if you don't have a long list of people to appoint, or if you just want to make sure that if there's no one else appointed in the document, at least there is, some institution or organization that's in there if there's no one else available to serve as trustee. So the document that people with children with special needs really focus on, and rightly so, is a special needs trust. And there's a number of different terms that are used when describing this type of a trust. You may have heard of the term supplemental benefits trust, supplemental needs trust, special needs trust. They are all talking about the same type of trust, and it's a trust that at its very core says that the money is available for the benefit of your child, but that the money in that trust cannot be used for anything that government benefits otherwise provide for. So in other words, the trust assets can supplement but cannot supplant government benefits. The government benefits that these trusts are really talking about are food, clothing, and shelter. So to the extent that you have a child at some point that is receiving government benefits, typically through Social Security or Medicaid, then whatever benefits they're receiving should first go to pay for these expenses. To the extent that the money is not sufficient to cover these expenses, that's where the supplemental benefits trust or special needs trust money can be used to essentially pay for all of those additional expenses that your child may have, including expenses that are really just to make their quality of life better. So, vacations, computers, movies, any of those types of activities or programs or extras that improve your child's quality of life while still receiving potentially some of the government benefits that they may be entitled to. So anything that is left in a properly structured special needs trust does not count against your child for purposes of qualifying for certain benefits. So when you hear about benefits such as Medicaid that has a income limitation and an asset limitation, it doesn't matter how much money is held in a special needs trust, that money in the special needs trust will not be considered as part of your child's assets for purposes of qualifying for these benefits. So it's very important that not only within your own planning that you have a special needs trust that is set up to essentially receive the assets that you are leaving to a child. But if you set up a trust as a separate document right now, even if you don't put any money in it yourself, you have a trust that's set up that you can let friends and family members know who may want to either leave a gift for a child during lifetime, birthday gifts, etc., graduation gifts, or if they want to leave money for your child under their will, they should be leaving the money to this special needs trust and not directly to a child, because they leave the money directly to a child, now we're putting money back into the child's name, which could disqualify them from whatever benefits either they are receiving at that time or that they could receive in the future. So most people set these trusts up as currently. So they set up what we call an inter vivos trust, a trust that's set up during life, It can be revocable or irrevocable if you don't have any money going into it right now, but you want to set it up so that if someone, wants to name the trust under their will as a beneficiary, we can have the trust be revocable so you can change its terms until the money actually goes into the trust, at which point it would become irrevocable. So we certainly include flexibility in the trust to make certain changes to trustees or to the structure of the trust until money goes into it. There are some people that say the only money that my child will receive will come from me or come from my spouse and only at our death. In that case, you can put the special needs trust language simply within your will. Essentially, your will would say any assets that go to my child go to a trust and these are the terms. But most people have other people in their life that either want to give gifts or want to leave money under a will, and in that circumstance, you should definitely have the trust set up currently so that it can be one bucket where any assets that are gifts or bequests are coming to your child can come into that one bucket. And very frequently, one or more of the parents are the trustees, so certainly during your lifetime, if there's someone else that leaves money to your child, you have the ability to be the one to decide how the money is invested, when and if distributions are made, and then the trust would say when you could no longer serve at your death, there would be that list of successor trustees that would be in place. The trust can say that the money goes wherever you want it to go at your child's death. Very frequently, what these trusts say is if your child has their own children, it goes to your grandchildren. If they don't, it would go to your other children if you had any. It stays typically within your own bloodline. And then, of course, you can say, what happens in the event that your entire immediate family is deceased. The money can go to other family members, charities, etc. So you dictate at the time that the trust is set up exactly all of the terms of the trust and where the money goes. And it's important that these trusts are very flexible in a number of ways because, of course, we don't know what the future is going to hold for our children, particularly if you have young children who, may have a diagnosis of some sort, but you don't know what the future may hold. They may have no trouble in life, holding a job, supporting themselves. The idea that they may need government benefits in the future may or may not be the reality. But so we're able within these trusts to essentially say, if your child is eligible for government benefits or is otherwise receiving government benefits, it's a special needs trust. If your child has a job and is working and otherwise, because of those reasons, does not qualify for government benefits, then it's simply a trust that's for that child's benefit, just like you would have a trust for your other children's benefit. I have a lot of parents who, particularly with younger children, who are concerned that they are putting their children into a box of some sort and that somehow by having this trust drafted the way it is or called a special needs trust or that has this kind of language in it, that somehow you're restricting what your child is able to do in life or at least what the money can be used for. And that's simply not the case if you have a trust that's drafted in such a way that really anticipates that circumstances can change and that, children's needs can change and, frankly, that the nature of, government benefits and the qualifications can change over time. So it's important to, though, plan for the fact that your child may receive government benefits because it's always better to have all of these assets that a child has go into this trust. If they don't need or qualify for government benefits, then this money is still available to them. It's just that someone else is in control of it. If they do need government benefits, they still have all this money that's in this trust for them that can pay for all of the extras. So another part of the estate planning is thinking about how much money should you leave to the special needs trust versus how much money that you leave to your other children. And this is certainly a struggle for some families. There's some families that say, I understand that, my children have different needs, but I want to treat them all the same. There are some families that feel that their child with special needs has, lifelong issues that may prevent them from being able to support themselves, whereas maybe you have other children that at some point you feel will support themselves, and maybe you want to put more assets in the special needs trust and leave less to your other children. There are also a number of parents that feel that they want to put more in the special needs trust, but they don't want to have a will that says that they leave things unequally to the three kids. So in that circumstance, you may have something like a life insurance policy that pays into the special needs trust in order to provide that special needs trust with additional assets. And another document that you should have also, which is not a legal document, but it's a letter of intent, and that's a document that we recommend that you update every year. And it's really a letter that is helpful for whoever is going to be taking care of your child down the road, whether it's the guardian or the trustee. And it's a place where you can, put down a list of, doctors and people that have been helpful to your child along the way through therapies, et cetera. And also it's a way that you can express to your trustee and your guardian your hopes and dreams and desires for your child and how you hope that they would be taken care of in the future should you unfortunately no longer be available to do so. That is a document that, by the way, I'm happy to send anyone. We have a couple different forms. So if you send me an email, I'm happy to send that document to you in Word form so you have at least a template to start. So state laws can affect the structure of special needs trust. Each state has different rules. So, the rules in New Jersey, for example, are different than the rules in Connecticut. So, again, we draft our trust so that the trust can be changed if the child moves to another state in the future. But it's something to keep in mind that if your child moves around the country in the future, that you just want to make sure that wherever they end up, that the trust that you have for them is reviewed by an attorney in that state just to make sure that it still complies with the rules of that state. When you prepare your wills and you prepare your special needs trust, you can have the most perfectly drafted documents, but if you don't have all of the assets essentially flowing into that special needs trust, then you haven't accomplished very much. So the wills dictate what happens to assets like bank accounts, real estate, assets that are called probate assets. Those are assets that your will controls. But a number of people have assets such as retirement plans, life insurance, that go by beneficiary designation. So when you sit down and you put your estate plan together, you put together the wills, the special needs trust, a very important component of that is making sure that your retirement plans and your life insurance and your other assets are tied into the planning. So that's a matter of making sure that the beneficiary designations are appropriate based on the plan that you have in place. I'm not going to spend a lot of time on the tax planning. Suffice it to say that there is a federal estate tax right now. There is a New Jersey estate tax until next year under current law. Under federal law, everyone has a $5.5 million estate tax exemption. Under New Jersey law for 2017, there's a $2 million exemption. In 2018, the tax is scheduled to go away completely. So certainly, if you are, in any of those tax brackets, we would want to make sure that from a tax standpoint, we're also planning appropriately. But I don't want to spend too much time on that because I want to make sure that I'm hitting the special needs aspects of the program. So moving on to planning for the actual child with special needs. So if there are children that have assets already in their own names, either because money was put away when a child was very young and that's now grown significantly, or a child may have, a lawsuit or some kind of recovery if there was a medical malpractice issue. That money will make them, depending on the amount, could make them ineligible for certain benefits. So there are different ways to deal with the money that may be in a child's name currently in order to put them in a position to qualify for government benefits. For more substantial amounts of money, one option is what we call a first-party special needs trust, and that's essentially a trust that holds your child's own money. So it's a first-party trust because it's money coming from your child. It's money already in your child's name that really needs to be put somewhere so that your child can become eligible for benefits. The downside of these trusts are that they have to have at your child's death a provision that says that any expenditures that Medicaid has spent on your child during your child's lifetime has to be paid back from the assets in this trust at your child's death. So because Medicaid, which is run by the states, has an interest in what happens to this trust, the states heavily monitor how the money is invested and how the money is spent in these trusts. So it's really, when we talk to clients whose children have money in their own names and the decision about whether to use a first-party trust or not, one of the discussions we have is to let them know that they're not going to be free to use this money for the child like they would be in a third-party trust where money is coming from other relatives or from people other than the child. In the first-party trust, you have to give notice if you're spending over $5,000. You have to have an annual accounting that you have to submit to the state, and they really do go through it with a fine-tooth comb. So typically, this is not something that we recommend unless there are fairly substantial assets in a child's name where this may be the only choice in order to qualify the child for benefits. Another choice that people have, another option for amounts that are a little bit smaller is something called a pooled trust. And that's like a first-party trust, except that it's a trust account that's set up typically by a nonprofit, and it's just a lot less money on your end to set the trust up and to administer the trust. It's basically an account that's funded with the child's money and that's held at a nonprofit, and the nonprofit essentially acts as the trustee of that money. And so that's appropriate when you're talking about smaller amounts. There's also, to give you an example, I spoke with a client today who has a child who's about to turn 18, and that child has about $20,000 in a bank account. And we talked about the different options, and one of the options was that the parent who has expended, an extraordinary amount of money over the years on various therapies and tutors, much more than has been expended on, care for the other kids, that you can reimburse yourself with essentially the money that's in your child's name. You should have receipts and documentation to substantiate the reimbursement, but it's another way to remove that money from the child's name without, legitimately, without causing, Medicaid to say that your child was essentially giving you a gift. You're basically reimbursing yourself for expenses that you have made on behalf of your child that are somewhat extraordinary. Another option that has come into play in the last year or so are called ABLE accounts. And ABLE accounts are similar in a way to a 529 account for education, but the purpose of the ABLE account is to, instead of using the money for educational purpose, it's a way to set money aside for a person with special needs and certain disabilities that are defined, and to allow that money to grow tax-free, similar to a 529 account. However, the ABLE account has some very significant limitations to it that, in my opinion, make it an interesting, an interesting concept that can be used, I think, for some limited, discrete purposes. But certainly an ABLE account will never take the place of a special needs trust for assets that a child's receiving from you. And that's because, number one, the ABLE account, even though money can come from a third party, the ABLE account has that requirement that there be a payback to Medicaid at a child's death for anything that was expended on that child's behalf. So you as a parent are not going to want to put a lot of money into an ABLE account where there's a payback when you can set up a special needs trust where there's no payback provision. So that's one part of the ABLE account that makes it not nearly as attractive as a special needs trust. There's also limitations on how much money can be put in each year. All donors combined can only put in $14,000 total. So it's not per donor, it's total. So if you have 14 people, those 14 people can only put in $1,000 a year so that you don't go over that $14,000 a year threshold. Income earned is not taxable so long as it's used for qualified expenses related to disability. Unfortunately, the rollout of these plans has been pretty slow. Every state has its own plan and its own nuances, but the description and the list of qualified expenses is being put out by the IRS, and the last time I checked, that this was still a work in progress. To the extent that money is taken out of the account and it's used for any purposes that are not on that list, there is going to be an income tax on the income and a 10% penalty. Again, that's somewhat similar to the way 529 plans work. Must contain the Medicaid payback, which I talked about. And the total amount in the account at any given time cannot exceed $100,000, or every dollar over $100,000 starts to count as an asset for the child for purposes of Social Security income. So again, there's a limitation on the total amount that can be held in this trust. The idea is that they want you to be able to keep $100,000 or less and have this money not count against your child, but when it's over 100, it starts to count against your child, just as if the child had this money in their own name. So, for these reasons, I think that the ABLE account is not, a panacea. That I think that some articles, at least when the ABLE Act was contemplated, were talking about that this would be, an easy way for people to essentially put money away. It could be like a special needs trust, but you don't have to set the trust up. All of these limitations make it, obviously, in my opinion, only useful in limited circumstances. And where I've I've talked to clients where we tried to identify whether or not an ABLE account makes sense. It seems to make sense for, for example, if you have a child that's making a small amount of money, and you want to teach them how to save, and you want them to be able to put some money away, but not have to spend all that money in any given month in order to continue to qualify for benefits. You want it to be able to accumulate, but we're not talking about a substantial amount of money. An ABLE account may be a great place to park those funds. If you have, people that are looking to give very small gifts, and you feel comfortable that the money will be used up by your child during lifetime so that it never gets paid back to the state, that may be a use for the ABLE account. But in most circumstances, a special needs trust is still necessary, even with the advent of the ABLE account. One other qualification is that the beneficiaries must be severely disabled, which again is a defined term, before reaching the age of 26. So these are not accounts that can be set up for anyone who may become disabled after the age of 26. I already spoke about life insurance, which can be a very good way of funding special needs trusts if there's a lack of liquidity in your estate, and you want to make sure that there's liquid assets for your child, because your child with special needs may have lifelong financial needs that maybe you can't provide for from other assets. So certainly life insurance is an important funding mechanism for special needs trusts for many people. And also, once a child turns age 18, there's a decision about whether a guardianship makes sense or whether your child can simply sign a power of attorney and a healthcare proxy on their own, allowing you as the parents to help them with their financial decisions and to make healthcare decisions for them. And really the decision about whether you go with a guardianship, a full guardianship, a partial guardianship, or not is, of course, completely dependent upon your child's level of ability to handle all of these financial and personal and medical decisions on their own. So for some children, they need full guardianship. They're incapable of making decisions, managing money. That would be an instance where once the child turns 18, you submit an application to the court to be appointed as legal guardian. Obviously, there are doctor's reports that are required. The judge will appoint an attorney that acts on behalf of your child just to make sure that your child is being adequately represented and that, in fact, your child really is in a situation where they do need a legal guardian after the age of 18. There are partial guardianships. Partial guardianship would be appropriate in a case where maybe your child has some ability to handle finances or make decisions. Maybe you want to make sure your child, for example, still has the right to vote, the right to get married, certain legal rights that anyone who turns 18 has. So there may be circumstances where those types of legal matters you want your child to retain, but there are other matters where it's appropriate for the parent to be named the legal guardian. If you have a child that can, make these types of decisions on their own, but otherwise just needs some help, the power of attorney and the healthcare proxy naming the parents or a sibling or someone may be all that's needed. So again, it's very much on a case-by-case basis, and it's something that you start to discuss around the age of 17 to figure out what's most appropriate in conjunction with, of course, the medical professionals and the other people that are in your children's lives. So it is, a court procedure. A complaint has to be filed. There's affidavits that are filed by doctors. The judge will sometimes order a hearing if he or she wants to hear from the parents or hear from the court-appointed lawyer or hear from the doctors. It's not all that common, but it can happen. Particularly if a judge has any question about whether or not the guardianship is appropriate. And then ultimately, assuming that the judge agrees that it's appropriate, the judge issues a judgment that essentially names typically both parents, but it can be one parent or the other, as the legal guardian. This is, again, the court-appointed attorney, interviews the parents, interviews the child, and issues a report to the court either agreeing that a guardianship is needed or not. And again, unfortunately, the courts used to be a little bit more lenient on the timing. We used to be able to file a guardianship a couple months before a child's 18th birthday in the hopes that by the time they're 18, the order would be issued and there would not be any lag time in between 18th birthday and guardianship. The counties have now, most of the counties now won't even accept the guardianship application until the 18th birthday. So usually we try to get everything teed up so that we can submit it right on the 18th birthday. The process usually takes 1 to 2 months, so it can be a stressful time for parents when they feel a little bit in a state of limbo. But the judges do seem to understand that, and assuming that all of the ducks are in a row prior to the age of 18, we typically can get them through as expedited as possible. But it's just something to keep in mind that there may be a period of time where technically you do not have legal guardianship. Obviously, if something dramatic happened during that time that we were waiting, a child had a medical issue, certainly you could rush to the court and have that dealt with on an emergent basis. But the typical time frame is usually about 4 to 6 weeks. So here's my contact information. Again, I'm an attorney at Schotz, and here's my phone number and my email. I'm happy to review documents. If any of you have existing documents and you either don't know what they say or they haven't been looked at for a while or you're not sure whether you have a special needs trust, or if you do, whether it's still compliant, I'm happy to take a look at that for you and give you recommendations. Also happy to answer any questions, and everybody's circumstances are quite different, so certainly happy to get on a phone call with anybody and talk through any particular circumstances or questions that you may have. And I appreciate you guys listening today. I don't know if you want to, if anyone has any questions, I'm happy to answer them if they think that it's something that the group could benefit from. There's also a Q&A button, I believe, on your webpage that you can ask as well. Otherwise, I'm in Hackensack in New York, and you can certainly contact me, and I'm happy to discuss.
Well, Mary, this is Mary Jane from Alpine Learning Group. I want to thank you for taking time to speak to us this evening. It was really informative, and like Mary said, if anybody has any questions they want to throw out here, or if you feel more comfortable maybe contacting Mary privately, here's her information. I certainly will be emailing out her contact information to everybody as well, probably tomorrow or Monday.
Okay, great. Thanks, Mary Jane.
Thank you so much. Well, if nobody has any questions, enjoy this Thursday evening, and be well, everyone.
Great.
Thank you.
Thank you so much. Goodbye.
Thank you.